So today's session, the conversation that we have, the title of the session is The Need for a Constitutional Court. And the larger theme of this conference this year is about constitutional crisis in South Asia. We've just had a very robust conversation on this in the inaugural session on some of the problems, challenges, both in Pakistan and across the region. And in this session, we will attempt to perhaps narrow it down, have a more focused discussion on this. We have a very esteemed panel for this conversation. We are very honored to have Mr. Raza Rabbani with us. If I may request Raza Rabbani sahab to come on the stage. He needs... Raza Saab needs no introduction. He has been a law minister, he's been the chairman of the Senate, but most importantly, Raza Saab over the past nearly 4 decades now has been one of the most vocal and articulate voices for federalism, for democracy, and we're delighted to have him here. We have with us Dr. Sadaf Aziz. Dr. Sadaf Aziz is the dean of the Shaikh Hassan School of Law at LUMS. And she is a scholar of international renown, has recently published on the Pakistan Constitution, a book. We're honored to have Mr. Rashid A.Rizvi with us. Again, Rizvi Saab needs no introduction. Rizvi Saab has been is one of the leading lawyers of Pakistan, but he has a lifetime of commitment to human rights, to due process, to the rule of law, and equally importantly, Rizvi Saab has been a participant and witness to the lawyers' movement, but to much other political activities which one hopes would inform this discussion today. Last but not least, we have Professor Antonio Martin from Barcelona. Again, he is a scholar who teaches constitutional law at the University of Barcelona, has an extensive experience in the field of comparative constitutional law, and we're very grateful to have him here. The format of this discussion, we hope, would be more of a conversation, but before we begin, I think if I may ask Raza Rabbani Saab to, given the topic, given the subject, which is the need for a constitutional court, for him to give some opening remarks. I can preface it with some background, which is that in 2006, when the Charter of Democracy, a key moment in Pakistan's history, particularly recent democratic history, happened, and Raza Saab was an instrumental figure in that process. For the first time in recent history, we saw the demand that there needs to be a separate constitutional court. So a bifurcation between the functions of the Supreme Court as it functions as an appellate court, as a court hearing regular cases in a constitutional court. And we'll sort of, if Raza Saab in his remarks can also reflect on that and what has happened since. So I'll ask Raza Saab to open with his remarks. So we can.
First of all, speakers sitting on the podium, the distinguished Minister for Law, ladies and gentlemen, and my dear students. I was told that this is to be more of a conversation, and therefore I have tried to limit myself to a written text so that I don't go on rambling and that we can have more of a question and answer and a conversation amongst ourselves. As far as the topic is concerned, I have always found that an engagement with the Constitution of Pakistan, 1973, is like being in love. And that is for the simple fact that there is never a moment without anxiety. The Constitutional Court, as you all know, is an exercise only, is a special court that exercises only the power of constitutional review. The system was introduced by the Austrian scholar Hans Kelsen and is founded in the European states such as Austria, Germany, Italy, Spain, and its influence has also carried to Colombia, Russia, the Republic of Korea, Turkey, and Taiwan. The motivation in establishing the Constitutional Court is to create a strong and specialized judicial type of a body capable of enforcing a new constitution or a new constitutional deal. What is more important is that the court is also empowered to decide on abstract questions. For example, it may have the power to examine the constitutionality of a law even before it is passed by Parliament. And I would like to lay emphasis particularly on this issue. The following and collectively are the powers that may be exercised by a constitutional court. Number one, constitutional drafting jurisdiction, that is, controlling the Constitution itself. Number two, judicial review of legislative acts, controlling the legislature. Number three, jurisdiction over officials and agencies, controlling the executive. Number four, jurisdiction over political parties and elections, controlling elections. It is not simpliciter, a court that adjudicates on constitutional disputes, but has wide-ranging implications. A reference was made to the Charter of Democracy, and yes, it is a fact that in the Charter of Democracy, it was stated that a constitutional court would come into existence. But then at the time, when we were drafting the 18th Amendment, and which was an extensive period of time, something like over 9 months, during that period, an extensive discussion was held on whether a constitutional court, as envisaged by the Charter of Democracy, was needed or not. And we came to the conclusion at that time that at least for the moment, a constitutional court was not needed. And the reason for that being the complexity of the powers that are flowing from a constitutional court. Number two, an additional structure was to be added to the federal judiciary, with already the Federal Shariat Court and the Supreme Court. It was in our mind to do away with the Federal Shariat Court. But unfortunately, because we didn't have the numbers in terms of a two-third majority, without the religious right supporting us, and then they brought in question the entire 18th Amendment. Had any of the Islamic provisions in the Constitution be touched, therefore we were compelled to continue with the present structure. Number three was the volume of work. It is today that one finds that there is a spat of constitutional issues that are being raised in courts. But in normal course, if governments are running according to the Constitution, and if the system is functioning, then the quantum of work would not justify a court. The other issue that was taken up at that time was that we recommended that in the Supreme Court itself, there should be a constitutional bench which would look at constitutional issues. But having said that, I think what one needs to do is to look at the Constitution itself. Because the Constitution itself of 1973 provides for a number of solutions to various issues that arise between the federal government and the provinces, between the provinces and the federal government. And one would then be questioning the fact that if one was to look at the Constitution and one was to follow the Constitution, would litigation in that stricto sensu terms really be necessary? Let me give you some of the examples. For example, if you look at Article 152 of the Constitution, which deals with acquisition of land, if there is a dispute that arises between the federal and the provincial government, the Chief Justice of Pakistan is to appoint an arbiter. Number two, if you look at Articles 153 and 154 of the Constitution, you have the Council of Common Interest, and that in which a provincial and the federal government are represented. And if there is a dispute, or if one of the parties, that is the federal government or the provincial government, is not in agreement with the decision of the Council of Common Interest, then it can take that decision to a joint sitting of Parliament, whose decision would be final. Similarly, if you look at Article 157 of the Constitution, which deals with electricity, and should a dispute arise between the federal government and the provinces, it is to be referred to the Council of Common Interest. Similarly, Article 156 of the Constitution, priority of requirements of natural gas. This matter, in any case, falls within the domain of the Council of Common Interest. Article 159 of the Constitution, broadcasting and telecasting. In case of a dispute between the federal and the provincial governments, the Chief Justice is again to appoint an arbiter. But here we have moved an amendment in the Senate that since it is a matter which concerns the Federation, therefore instead of the Chief Justice, it should be the Senate which appoints the arbiter. So that amendment is still pending. Article 161 of the Constitution, it deals with natural gas and hydroelectric power. The article provides that the net profits are to be calculated on a formula which is to be determined by the Council of Common Interest. In Article 184 of the Constitution, 1973, the original jurisdiction of the Supreme Court deals with disputes between two governments. Article 186 of the Constitution, the executive may refer a question in the advisory jurisdiction of the Supreme Court. But having said that, and why have I gone to taxing you and walking you through the Constitution? I have to say with a great deal of respect and with a heavy heart that since 1947 till today, there has been a historical nexus in the power equation between Pakistan's establishment and the judiciary. This power equation, which is dominated by Pakistan's establishment, at convenience picks up stakeholders to join them in perpetuating their power, to join them in the exploitation of the resources of the provinces. And therefore we have found that at different times, military takeovers have been given a legal cover. We have found that after the military takeover is over, yes, you may have a judgment calling a person a usurper. But at the nick of the time, they have been justified under the doctrine of political necessity. We have also found that there have been times when the military dictatorship has not asked for the powers to amend the Constitution, but those powers have been given, regardless of their asking to amend the Constitution. But as time has gone on and the military dictators have found that it is more convenient, rather than abrogating the Constitution, because they are aware of the fact that the 73 Constitution is such a document for which a national consensus amongst the federating units and amongst the stakeholders may not be possible. So therefore we have had new terms, the Constitution being held in abeyance, certain articles of the Constitution being suspended, and now we have a new doctrine. And that new doctrine is the doctrine of reading in. And in the doctrine of reading in, we find that regardless of the fact that in the Aam Log Ittihad Party case, which is PLD probably 2022, regardless of the difficult test that the court itself has laid down, but yet when it comes to giving a push, that test is thrown to the winds. And you have the doctrine of reading in, and now I was really taken aback. In fact, as a member of parliament, I was thinking as to whether there is any need of parliament now or not. Particularly after I went through the detailed reasoning in the presidential reference on Article 63A of the Constitution. The manner in which the doctrine of reading in has been justified, quoting foreign jurisdictions, in particular that of the United States. But what we must realize is that there is a vast difference between the United States and the ground situation in Pakistan. Essentially, the United States has a presidential form of government. Pakistan has a parliamentary form of government, or at least that is what we hope it will have. But having said that, why I have changed my mind is because of the nexus, because of the obtaining objective conditions What in actual fact is needed is for all of us, including myself, and I include myself as number one. What is needed is a change in the mindset. Until and unless we change our mindset, we can have no matter what type of legislation, but it will end up at naught. You can have no matter what type of courts, but if the mindset continues to be the same, then the net result would also be the same. In conclusion, I would just like to say this much, that I believe, and the Constitution so provides, that Pakistan is a federation. And after the 18th Amendment, Pakistan has become a participatory federalism. And in a participatory federalism, I think what needs to be done is we need to go back. We need to go back to the Government of India Act 1935, when the Supreme Court was known as the Federal Court. I think it would not be a bad idea, if the Law Minister is here, if it would now once again, keeping in view the federal character of the state, if it was to be called as the Federal Court. And while calling it a Federal Court, I would also stress that being a federation, we must keep in mind that there is representation, if not equal, but then there is representation on the bench in terms of the provinces. We must also bear in mind that while keeping this one issue of the provinces in mind, the criteria must also be laid down to the appointment of judges, in which seniority should be paramount. And I think that once there is a change in the mindset, then of course one can revisit the question, according to me, of whether a constitutional court is required or not. Thank you very much.
Thank you, Raza Saab, for these very eloquent opening remarks, which set the tone for our conversation, in my opinion, very nicely in terms of giving the focus and direction. Now, while moving on to Rashid Rizvi Saab, part of this conversation when this was happening about a separate constitutional court, part of the thinking was that Pakistan has the Pakistani Supreme Court has too much power, which means that, as Raza Saab gave the example of the Article 63A judgment, where there is a difference between interpretation and reading in, and there is too much, the Supreme Court of Pakistan, having both all appellate jurisdiction, having all constitutional interpretation jurisdiction, has the power converges institutionally in the Supreme Court, and within the Supreme Court it converges in the Chief Justice. So when you looking now from the, let's say from 2007 to now, with the lawyers' movement in the middle really, and now in the post-lawyers movement judiciary, do you think that the Pakistan Supreme Court now is just too powerful a Supreme Court in a democracy?
Yes, I will agree with you. Generally what we said after the lawyers' movement, which was for the independence of judiciary, कि अदलिया अब मादर पिदर आज़ाद हो गई है. They don't have any limit of the jurisdiction. Their decisions are based on much more on likes and dislikes. There is no regulatory provisions how to deal with the suo motu cases, how to regulate urgent matters and old matters and regular matters. They have totally forgotten what was decided by their peers in 1950, 60, 70, 80, 90. Their conduct has become so authoritative that even if a lawyer comes before the rostrum, they announce their decision, dismiss. I think judiciary has become more powerful after 2007. And unfortunately, I would like to take advantage of Mr. Raza Rabbani's presence. At the time of framing 18th Amendment, they missed this opportunity to limit the jurisdiction of Supreme Court and suo motu jurisdiction. Even they failed to provide the appellate forum for a decision passed under Article 184(3). And that has made the judiciary unchanged. They have become absolute power. And now, after the recent decision of judges, all suo motu matters is to be dealt with by the Chief Justice Pakistan. He has become more authoritative. That should have been within the senior judges with some other regulatory provisions. But I agree with you that after 2007, the judiciary is, and it is the time that something should be done. My friend, Mr. Azam Nazir Tara, learned law minister, is here. Mr. Raza Rabbani, former chairman, is here. अगर अभी भी लगाम नहीं डाले तो बहुत मुश्किल होगी.
Okay. Thank you, Rizvi Saab. Now moving to Dr. Aziz, I think on a conceptual level, when we make this distinction between a constitutional court and a Supreme Court, like Raza Saab said about between a federal court and a Supreme Court, and we saw that before this constitution, we had a federal court. What at a practical level, how, even if we were to make a constitutional court, what would that entail? I mean, how would that, because in Pakistan, the high courts are constitutional courts. They have writ jurisdictions, so it's not only the Supreme Court. So if we were going to make a court which is only specifically vested with, has the authority of, and passes decisions on constitutional matters, how would that, given the Pakistani framework, would work? How would we make, if we were to make a constitutional court, how would we go about it?
Well, I mean, certainly. Thank you, Saroop. Thank you, Raza Rabbani Saab. Thank you, everybody, for your comments so far. And Raza Rabbani Saab ke to comments were really illustrative, I think, and went quite deep in terms of investigating and illustrating ke actual design features kya hone padenge if there is a constitutional court. So fittingly, obviously, because it was suggested so many years ago with the Charter of Democracy, and as far as I know, that is the first time in our post-colonial history जिसमें ये concept उस तरह से arise हुआ है and came within the public domain. एक चीज़, actually just taking up from some of the things that you were saying, कि there is a change of a mindset which is necessary overall, so that you don't have these kind of deep encroachments on other powers. But I want to bring it back actually a little bit, because I think something about the Constitutional Court intersects with another very important domain जिसके बारे में आपने extensively बात की है, which is federalism. And if not federalism, because as you're saying, the 18th Amendment and all of its various provisions give dispute resolution mechanisms. एक तो see Council for Common Interest, which we know does not mean often enough, if at all, as an intergovernmental or intra-governmental organization. But one thing that I wanted to say, because what it spurred off for me, not just in the case of federalism, but when I think of rights adjudication in this country, over the last, even if we take it from 73 Constitution onwards, जिसमें इतनी elaborated हमारी fundamental rights हैं, along with that, with the case with federalism, even with the post-18th Amendment provisions, I think that the court has given us conflicting, judgments. So even where you have taken away some of the major issues, so when we talk about आपने जो provisions mentioned किए हैं, those were around resource allocation, ownership, dispute, but this very large domain of overlapping legislative jurisdiction. I feel like, and this is, I'm holding this at the back, that there may still be something to investigate in a constitutional court, which has both the resources, the time, and perhaps the insulation from other kinds of political pressure to work out, or to be able to both bring uniformity to vast expanses of jurisprudence, but also thereby to do it in a well-deliberated fashion. So I'll just briefly say that post-18th Amendment, हमारी legislative overlap has been reduced to now a mini concurrent list, but we have sort of conflicting judgments on the expanse of those vis-a-vis federal and provincial powers. On the other hand, there was another instance. In the powers of provincial governments to invoke, federal legislative powers in order to provide uniform legislation. And the reason why I think this is important, in addition to the fact that obviously this has to do with the very primary function of government at all levels, is the fact that so many of these legislative enactments actually intersect with labor rights, with welfare provisioning and things of that sort. So when we have unclear precedent, and we have precedent that conflicts in certain cases, then what we have is the apparatus of government which is at a standstill, oftentimes for the people who need it the most. So if these governmental agencies and the like are forestalled from acting because these legislative powers are not clear, then I think that's a problem. And so that brings forth, beyond the, and I know that today and on, in many occasions, of course, we think of the meta-political issues and the issues of political, sort of structures of government and office holders and their relative powers. But the other thing that I wanted to bring up again also and draw attention to the fact that in spite of a very long now, history of constitutionalism and fundamental rights adjudication, we again have very few points of clarity or doctrinal advancement when it comes to the adjudication of our fundamental rights. So briefly, if we think about Article 25, which is the right of equality and a right against discrimination, it's yet not very clear, what the tests are vis-a-vis the according of equality rights, what counts as discrimination that will be barred, when affirmative action can kick in. I think there's some developments happening, but again, the primary feature in those judgments has tended to be, and not just Article 25, but in the interpretation of all of our fundamental rights, is a great deal of deference to the government of the time or national security concerns. And as you know, all of us know, there are huge in our constitution and in the constitutional structure. And I wish that this had, perhaps had greater play at the time. That the 18th Amendment certainly was being authored, is the need for such wide clawbacks to our fundamental rights, which are written into the text of our fundamental rights, which then again encumber our judiciary from being able to provide the breadth of rights that as citizens we should be able to expect. But not just that. So that is the design feature, that is the textual feature of our constitutionally accorded rights. But the larger thing, obviously, also being that that is always only the beginning and the touchstone. And perhaps, and so again, in a way, Saroop, coming back to the question that you were asking, I guess the question that I would ask vis-a-vis whether or not we have constitutional courts which are separate from, or where you can sever the appellate jurisdiction of the highest court in the land, so that they are arbiters of the expanse of constitutional provisions and rights, will they have the wherewithal to do that? What would be the mechanisms in a design way that would ensure that the expertise and the independence was there? I mean, of course, as you mentioned, the independence of the judiciary, or Rashid Rizvi Saab ne bhi, has been the preeminent issue, of the last many years in terms of appointment of judges and the like. Would we have to, so Saroop, coming to your point, would we have to come up with a mechanism for appointment which was separate from the regular judiciary in order to ensure that? Because the issue of independence obviously is not a settled one, although valiantly fought for by the existing judiciary. Also, what would then be the safeguards and possibilities for a judiciary of that sort, or a pure constitutional court, to be able to bring greater depth and breadth into the articulation of rights and into issues particularly pertaining to federalism and the like?
Thank you, Dr. Aziz. I think that you have sort of brought much needed sort of nuance into when we think at the conceptual level. And moving this conversation to Professor Antonio Martin on the broad idea, as you heard. So in Pakistan there is the power of judicial review, there is the power of constitutional interpretation, which is vested in both the high courts, provincial high courts, and the Supreme Court. So Pakistan does have constitutional courts. The question initially was, from where we started, was should we have separate constitutional courts? But in Pakistan, it's complicated because, you worked on researched on constitutional law, comparative constitutional law, and the idea of constitutional courts is to be counter-majoritarian institutions, to be institutions which, essentially, amongst other things, is a check on democracy, is that where. But in Pakistan, I think it's complicated. I don't know if it's unique, where you have a populist judiciary, which is now, after a mass public movement about a decade ago, which now sees itself, and often says as much, that they embody the will of the people, they would act on the will of the people. And then the idea of the Supreme Court of Pakistan being a counter-majoritarian institution, which is that there is the parliament to uphold the will of the people. How does I mean, how would the principle of a constitutional court, and the example that, I mean, Article 63A, the detailed judgment example which is given, which it seems has gone beyond interpreting, I mean, to many people it seems, it goes beyond interpreting the language of the Constitution. It reads, as Raza Sahib said, reads in, or reads and interprets language which isn't there, which is rewriting. So then how do we grapple with that? There is the power to be a constitutional court, and we get the idea of being a counter-majoritarian court. And that's where freedom of religion, freedom of expression, so that court is, even if you have a government at a point which does not believe in these ideals, you will have at least a structure which the court protects. But if that is a court which says that we also embody the will of the people, then how does the principle of being a constitutional court would operate, or what complication would arise then?
Thank you very much, Saroop, for the question. To start with, well, I'd like to thank, of course, the AGHS, the Jahangir family, for the celebration of this event. And also, I want to thank the Spanish Embassy for participating in this event and for having brought me here, or told me that this event was taking place. For me, it's really an honor to come to Pakistan, which is a country that, left the world in awe in 2007, 2008, with the lawyers' movement. 2007, right? 7, 8. There was really a moment of big emotion in the legal community worldwide. Going to your question, we have to consider that the Constitution in and of itself embodies values, principles, and policies that might be at odds at a certain given moment with the power in place in a country. So there is the dichotomy between a constituent power and the constituted power. In a way, you can say that the people of Pakistan in 2022-23 is subjugated by the people of Pakistan in 1973. You can say so. Or you can also look at it from another perspective. You can say that the people of Pakistan in 2022 is guided by the people of Pakistan and the constituent power in Pakistan in 1973. And you can say that if that constitution is granted normativity, if that constitution is binding, and as if it seems it is, and there is judicial review, then that can give wisdom to the rulers of Pakistan in the year 2022, wisdom on the basis of the policies, principles, and values that were enshrined in the Constitution in 1973. Is that counter-majoritarian? Yes, but I think that the counter-majoritarian idea lies at the heart of the idea of a constitutional law. Also, in the case of the United States, the rulers of the United States are subjugated to what was decided in 1787. Of course, there is the power to modify the Constitution within the limits and according to the procedures set by the Constitutional Charter. Now, I think that you pointed at something interesting, which is the concept of judicial activism, and the threat that, in fact, the constitutional interpreter or the interpreter of the law, regardless of whether it is the Constitution or a legal act, that the interpreter of the law might be an activist and might be, in fact, exercising power, and not in the way that Montesquieu theorized about the legal interpreter, that should be the mouth that pronounces the words of the law, that is, as a no power, as a neutral power. In fact, according to the traditional theory of separation of powers, the legal interpreter should not wield power, should bow to the policy preferences, to the principles, and to the values that were decided by the decision makers, by the legislator or by the constituent or constitution maker. Now, the question, I think, maybe should be, can a constitutional court tackle the problem of judicial activism? I think that's an interesting question, but that goes to, to what has just been said. What kind of design can we give to the Constitutional Court to ensure that the Constitutional Court will not be an extension of the judicial activism carried out by the ordinary judges? And of course, there are many types of designs. Usually they are referred as the German model or the Italian model. Basically trying to bring consensus as to the appointment of the judges, granting tenure to the judges. In the case of the United States, judges have a mandate, a term for life. And in the case of other countries, their terms might be non-renewable. I am optimistic regarding the prospect of a constitutional court as a way of addressing judicial activism if the constitutional court is well designed. We've been discussing here, Mr. Saravana Muttu this morning mentioned something. He mentioned that there is a cultural factor that might go on its way regardless of what the institutions are. I personally think that statement should be nuanced. I think that in fact institutions can shape cultures. So I do think that the legislator or the constitution maker could create a sort of ivory tower where judges could be isolated, detached from the more or less from the reality, from the day-to-day politics, and decide. I know that it's a little bit of a utopian thought, but I have faith in it, and I think that with the proper institutional design, if we make sure that the constitutional court is not politicized, by instance, granting this kind of tenure guarantees. Also, another element of institutional design which could be very interesting in this aspect is by appointing the magistrates of the Constitutional Court by a lottery among certain people that might be eligible. So, for instance, taking all the people who are full professors of constitutional law in Pakistan, or all the high magistrates in Pakistan. And if there is no a big consensus between parliament, prime minister, and other instances of power, then there is a lottery. So to avoid that there is an institutional gridlock that might be very prejudicial for the constitutional architecture. So yes, I believe that I do think that constitutional courts are counter-majoritarian. I do not see that counter-majoritarianism to be a threat to democracy. One thing is majoritarian democracy, another thing is the consociative democracy. There are different ways of conceptualizing democracy, and counter-majoritarianism does not go necessarily against democracy. And I think that a constitutional court can tackle the problem of judicial activism. But I think that for that we need, of course, to pay a great deal of attention to the institutional design and to carry on a reform that pays respect to the lessons that have been experienced in other countries. So for that, I think that we need more events like this and more sharing of experiences. Thank you.
Thank you, Professor Antonio. I think I will ask a question. First to Raza Saab, and any panelist then can weigh in. But Raza Saab, after we've had this conversation, the 18th Amendment happened. And what we saw immediately, 18th amendment, post 18th Amendment, and because you mentioned the appointment of judges, Dr. Aziz mentioned the appointment of judges, Rashid Rizvi Sahab mentioned it, Professor Antonio mentioned it, and there was a consensus and there was an attempt to make the appointment of judges more transparent, a more inclusive, a more fair process. And there is no polite way of saying it. The then Chief Justice Iftihar Chaudhry Sahab held a gun to the Parliament's head and said, pass the 19th Amendment. And how does one deal with that? So he's saying that, you know, even if you make a constitutional amendment, the Supreme Court came this close to saying that we can adjudicate on the validity of constitutional amendments, and it precipitated the passing of the 19th Amendment. Then we get into that space, which is a question that I asked Rashid Rizvi Sahab, is we want a court which is independent, we want a court which is powerful, but we also want a court which is accountable, not in the sort of power, abuse of power sense, which is some conversation, but with some, in terms of charting out its jurisdiction, because that's what has happened. So your experience after the 18th Amendment and the 19th Amendment, which my understanding is the Parliament was pretty much left with no choice. From that experience, what is a reform idea that comes to your head, which you think where the court remains a powerful and independent actor, but there are just limits to it, where it can't overrule the 2/3 majority consensus of the Parliament. So if you want to.
You have put a rather difficult question. But I'm grateful to you. You have said a lot of things which I may have been chary in saying for the simple fact that I have to go back on before the bench also. So I'm grateful on that aspect. But coming back on a more serious note, देखिए, the Rashid Rizvi Sahab also mentioned the 18th Amendment and spoke about appellate jurisdiction, which we were unable to do. There were so many things that we wanted to do in the 18th Amendment, apart from the federal character of the Constitution. But there were certain political limitations. And I think those limitations were amply demonstrated when the 18th Amendment came, and we were then forced to do the 19th Amendment. But the story doesn't end there also. I have no qualms in admitting that Parliament compromised in doing the 19th Amendment. We compromised. But then what was the result of the compromise? What we tried to salvage by way of the compromise, we lost in terms of judgments. The 19th Amendment was also whittled down by petitions being filed and judgments coming, and some of the tone and tenor of the language of those judgments in the manner in which they treated Parliament is still a part of the various PLDs in which they are housed. So to be very honest and very frank with you, there was something which I was going to say yesterday. I was going to say tomorrow in the session I am, but I think let me say it now and repeat it tomorrow. And that is that आप इन चीज़ों को isolation में नहीं देख सकते. The judiciary or the parliament is not functioning in isolation. The situation prior to a couple of years was where there was a total monopoly of Pakistan's establishment. In particular, Pakistan's military establishment. Now, over the last 4 or 5 years, we have seen a gradual change. And that gradual change is that from monopoly, we are shifting to dominance. And in that shift in dominance, you find all the traditional stakeholders who were supporting the monopoly now scuttering around trying to find their own place. It's not that they don't know the Constitution. They know the Constitution very well. They know what is the trichotomy in the Constitution. But they feel that this is a period of transition, and in that transition, if there is as much encroachment I can do in my field, let me do it. And therefore, I believe that until and unless there is a holistic approach to the entire issue, looking at issues in isolation and trying to look for reform agendas in isolation is not going to work. You will have another 19th Amendment, and you will have another judgment which will follow it.
Thank you, Raza Saab. I think the conversation, the topic is a large one, and things that need to be said on this are many. And what we hope to, of course, do with this conversation was to at least highlight some of the complexities, not come up with solutions, because the Pakistani constitutional problems are many. But and so I'll now open this for about 15 minutes of questions. I mean, I don't know if there's a volunteer that I can take mics to people and what? 20 minutes of questions. Okay, 15 to 20 minutes of question is what I've gathered. And yes, I mean, and my request would be, of course, keep your questions brief, क्योंकि बहुत से ऐसे मौजूआत हैं, वुकला की गैदरिंग है, लोगों के अपने ख्यालात भी हैं, और ज़ाहिर है बहुत मुफीद ख्यालात होते हैं, मगर वो सवाल पे ज़्यादा फोकस रखें ताकि जो गुफ्तगू है, जो मकालमा है, वो सेशन के बाद भी हो सकता है. जी, इनके पास माइक अगर ले जाएं कोई.
Thank you very much, Saroop. Thanks a lot for giving me the chance. I am Nasser Javed Ghumman, Advocate Supreme Court and Deputy Attorney General. My question in the perspective of the two words, one by ex-law minister and my party's leader, word mindset, and Mr. Rizvi Sahib, bar leader, lagam. In this perspective, the Constitution gives Article 191 of the Constitution, wherein it has been said that subject to Constitution and law, word law, the Supreme Court may make rules regarding the prospectus and procedure of the court. For the ad interim period, till the Charter of Democracy is acted upon, Constitutional Court constituted, or a debate is going on, there is a mandate given to the Parliament that a law could be made, and the Supreme Court will make the rules in accordance with the law. The judges would be bound down under the law that when a constitutional petition comes, such that senior judges will be said, no personal liking or disliking will go in, and other procedure to put down that कि आपकी petition आ गई है, फारग हुई है, आप लगा नहीं रहे हैं उसकी petition. In this perspective, the law could be made by the Parliament, and then the rules will be made by, and there could be given a specific period in that law. The Supreme Court will make the rules in a period of subterfuge. In this regard, neither any party has talked, nor till today, 75 years has gone, and still 73 afterward, no law has been made. So what is the perspective and what the actual law, Mr. Sabi, has gone? میرا خیال ہے اس پہ کام ہو رہا ہے, اس پہ جناب کی میں.
جی آپ کا شکریہ. میرا خیال ہے اس کا میں آپ کو بالکل مختصر سا جواب دوں. آپ نے بالکل درست فرمایا کہ آرٹیکل 191 آئین کے اندر موجود ہے, لیکن جتنی بھی پارلیمنٹس آئی ہیں, اور اب میں کسی ایک سیاسی جماعت کی بات نہیں کر رہا, میں اپنی جماعت کو بھی اس میں شامل کرتا ہوں, جتنی بھی پارلیمنٹس آئی ہیں وہ کمپرومائز پارلیمنٹس آئی ہیں, اور ان میں اتنی ہمت نہیں تھی کہ وہ ایک ایسا قانون جو ہے وہ پاس کریں جس سے they would be seem to be rubbing the judiciary on the wrong side. لہٰذا اس کی وجہ سے پارلیمان کے اندر یہ قانون جو ہے وہ پاس نہیں ہوا, اور مجھے ایسی کوئی آئندہ بھی ایسی کوئی امید نظر نہیں آ رہی کہ بہت جلد ایسا قانون جو ہے وہ پارلیمنٹ لے کے آئے گی. جہاں تک آپ کی یہ بات ہے وہ بالکل درست ہے. جو ابھی اتنی کنٹروورسی چل رہی ہے ججز کی اپوائنٹمنٹ اور اس کے اوپر, اس پہ ایک قانون آ سکتا ہے جو براڈ پیرامیٹرز کو سیٹ کرے, اور سپریم کورٹ پھر اپنے رولز اکارڈنگلی مرتب کرے. لیکن جیسے میں نے آپ سے عرض کیا کہ میں نہیں سمجھتا کہ پارلیمنٹ اس وقت اس حالت میں ہے کہ وہ کوئی ایسا قانون لائے. موجودہ پارلیمنٹس جو پچھلے 4 سالوں سے آج دن تک چل رہی ہے, یہ ٹوٹلی ریڈنڈنٹ پارلیمنٹ ہو چکی ہے.
میں ایگری کروں گا رضا صاحب سے. بہت سی چیزیں پریکٹیکل اور وقت کے ساتھ آدمی کی سوچ بھی بدل جاتی ہے. ہم جب لاء کالج میں پڑھتے تھے 72 کا انٹرم کانسٹیٹیوشن تھا, اس وقت ہمیں پڑھایا گیا تھا کہ اس ملک میں آئین میں 3 ادارے دیے گئے ہیں, لیجسلیچر, جوڈیشری اینڈ ایگزیکٹو. لیکن اب جب میں اپنی زندگی کے آخری اوورز میں آ گیا ہوں, پتہ چلا ایک چوتھا ادارہ ہے جو آئین میں نہیں پڑھا جاتا, اور وہ سب سے مضبوط ہے.
یہ تھا کہ کانسٹیٹیوشنل کورٹ سے پہلے جو ابھی موجودہ کورٹ ہے, اس کو انڈیپینڈنس اٹ سیلف کے ان کی جو ایلیویشن ہے, ٹھیک ہے, اس کو انڈیپینڈنٹ کر دیا جائے کہ جو سپیریئر ہے وہ ایلیویٹ ہو, بجائے کہ یہ پک اینڈ چوز, اور جو کہ پچھلے کافی عرصے سے ہم فیس کر رہے ہیں کہ جب یہ ایلیویشن کا مسئلہ آتا ہے تو کافی زیادہ.
بالکل آپ صحیح کہہ رہے ہیں. سینیورٹی کا رول فالو کرنا چاہیے, اور یہی آپ کی پاکستان بار کونسل کا بھی سٹینڈ یہی ہے, تمام بار ایسوسیشن کا سٹینڈ یہی ہے. اور جہاں تک آپ نے انڈیپینڈنس آف جوڈیشری کی بات کی ہے, مجھے یاد آ رہا ہے انڈین سپریم کورٹ کے ایک جج تھے وینکٹ تارا میاں. انہوں نے ایک مشہور کیس تھا ہز ہولینس کیسوانندا بھارتی کیس, اس میں کہا تھا انڈیپینڈنس آف جوڈیشری کو ڈسکس کرتے ہوئے, اٹ از inner strength of a judge. It is inner strength of a judge which ensures independence of judiciary. اگر آپ کے ججز کمزور ہیں, بائس ہیں, انڈیپینڈنٹ نہیں ہیں, تو آپ دنیا کا بہترین آئین لے کے آ جائیں, فیصلے وہی ہوں گے, آپ کے خلاف ہوں گے. لیکن آپ دیکھیں 52-53 میں جب چیف کورٹ سندھ تھی, اس وقت کوئی ایسے قانون نہیں تھے, لیکن اس وقت کے ججوں نے سندھ چیف کورٹ کے مولوی تمز الدین خان کیس میں ایک تاریخی فیصلہ دیا تھا اس لیے کہ وہ ان کی انر اسٹرینتھ تھی. آج ہم ڈھونڈتے ہیں وہ انر اسٹرینتھ ہمیں ملتی نہیں ہے.
We are living in post-lawyers movement scenario now. What were the things you think that we missed, the bar associations missed, or what were the things which were to be taken notice of by the judiciary that our purpose of that lawyers movement was basically that rule of law, that the strengthening of constitution and democracy was to be strengthened, but we couldn't get those results from that constitution. And what do you think, because you were leading this movement from the front and we were just workers behind you?
اس میں شمیم صاحب یہی تھا کہ چیف جسٹس پاکستان کو ریسٹوریشن کی تحریک تھی, اس میں آزاد عدلیہ کے بھی سوال آیا, جمہوریت کا بھی سوال آیا, اس لیے کہ ماشاء اللہ ڈکٹیٹر بیٹھا ہوا تھا. اس میں ہم سے جو بعد میں غلطیاں ہوئی ہیں اس کا پھل ہمیں مل سکا, ہمارے تک پہنچ سکا. اور جوڈیشری جو ہے نا بے قابو ہوتی چلی گئی. جن لوگوں کو اپنے گھر صحیح کرنے تھے, ہم ان کے گھر کی دیواریں کھڑی کر رہے تھے, چھتیں ڈال رہے تھے, انہوں نے ہمیں باہر نکال کے اپنے جو پھر گھر بنانا شروع کیا, اس میں پڑوسیوں کے بھی, محلے والوں کے, سبوں کے گھر مسمار کر دیے, اور وہ قلعہ بن گیا ہے اب سپریم کورٹ, جس میں ہم اور آپ نہیں جا سکتے, ایک عام وکیل نہیں جا سکتا, ایک غریب آدمی نہیں جا سکتا ہے. میں آپ کو ایک بات کہوں, میں ایک دن سپریم کورٹ 3-3:30 بجے ختم ہوئی, میں ابھی باہر نکلا کورٹ 1 سے, میں جا رہا تھا, مجھے معذرت کے ساتھ پنجابی آتی نہیں ہے, لیکن ایک صاحب نے موبائل پہ بات کرنی شروع کی, بیچارے ولیجر لگتے تھے مجھے, کہنے لگے تھے انصاف لینا آئے سی وہ تاریخ لے کے جا رہے ہیں. تو ہمارا یہ جوڈیشل سسٹم ہے, جب تک یہ آپ نہیں بدلیں گے اس وقت تک لوگوں کو ریلیف نہیں ملے گا, لوگ خوش نہیں ہوں گے.
یہ دو آخری سوال کر لیں, اس کے بعد پھر باقی سیشن کے بعد.
میرا کویسچن, ابھی 2 الفاظ استعمال ہوئے ہیں, ایک لگام اور ایک چوتھا ادارہ. تو لگام کسی اور انسٹیٹیوشن کے لیے استعمال ہوا ہے, چوتھا ادارہ کسی, کیا یہ دونوں اکٹھے ایک ادارے کے لیے استعمال ہو سکتے ہیں؟
آپ کا سوال میں جواب ہے. دل تو چاہتا ہے کہ چوتھے کو بھی لگام دیا جائے.
My name is Ahmad and I am from Punjab University Law College. So میرا سوال جو ہے نا وہ اسٹرکچر کے حوالے سے ہے کہ اگر آپ کانسٹیٹیوشن کورٹس بناتے ہیں تو 2-3 میجر ایشوز بھی ہمیں آئیں گے. لائک جو ہائی کورٹ ہے وہ بھی اس وقت جو ہے وہ فیڈریشن کے جو کہہ لیں کہ جوڈیشل ریویو کے مسئلے ہیں وہ حل کرتی ہے. تو اگر آپ وہ مسئلہ بھی ان سے لے لیتے ہیں, لائک آپ اوریجنل جورسڈکشن لے لیتے ہیں ہائی کورٹ سے, تو وہ معاملات بھی پھر سینٹر میں آئیں, ایک لڑائی جو ہے وہ اسٹارٹ ہو جائے گی. اور جو دوسرے ڈیسیجنز ہیں, لائک اگر ہم فرانس وغیرہ میں دیکھیں تو دوسرے ادارے لائک ECP کے جو ہوتے ہیں کہ آپ ریفرینڈم وغیرہ کرواتے ہیں, اور یہ والا کام بھی جو ہے وہ کانسٹیٹیوشن کورٹس کرتی ہے. ٹھیک ہے, تو آپ باقی ایک پورا ایک فرسٹ کریٹ کر دیں گے کہ وہ ساری پاورز دوبارہ ریلوکیٹ ہوں گی کانسٹیٹیوشن کورٹس کے پاس. اور جو تیسری مین چیز ہے وہ یہ ہے کہ جو اس وقت پولیٹیسائزیشن آف جوڈیشری ہے, اس کے اندر بڑا کہا جاتا ہے کہ جناب ہمارا ٹرائل وغیرہ کیا جاتا ہے میڈیا کے اوپر, تو اس سے بچنے کے لیے اگر آپ کانسٹیٹیوشن کورٹس بنا رہے ہیں تو کیا کہتے ہیں اسے, کہ اس کو کس طرح پھر میڈیا ٹرائل سے بچائیں گے تھرو کہ آپ اس کو نیچے سے اوپر لے کے آ رہے ہیں, تو اس کو کس طرح جو ہے نا کمپیل کریں گے. تو یہ 3 میجر کوشچنز ہیں اور اسٹرکچر کے حوالے سے ہیں.
دیکھیں, میں آپ کو بتاؤں کہ جہاں تک آرٹیکل 199 کے سو موٹو جورسڈکشن کی بات ہے, گزشتہ 5-6 سالوں میں بہت سے فیصلے اس پر آئے ہیں سپریم کورٹ کے کہ ہائی کورٹس کو سو موٹو جورسڈکشن کا اختیار نہیں ہے, انلیس ان کے پاس آرٹیکل 199 کی کانسٹیٹیوشن پٹیشن ہے, وہ تبھی جورسڈکشن انووک کر سکتے ہیں. رہا سپریم کورٹ یا کانسٹیٹیوشنل کورٹ کا, تو آپ اور 100 کورٹ بنا لیں. میرا تجربہ یہ ہے کہ جب تک آپ کا جو لا ہے, کانسٹیٹیوشن ہے, میں بالکل ایگری کروں گا میاں رضا ربانی صاحب کے ساتھ کہ یہ تمام کمپلیٹ ہے, سارے مسئلے کا حل ہے. جو چیز کی ہمیں کمی ہے وہ یہ ہے کہ جو امپلیمنٹ کرنے والے ہیں وہ کس حد تک انڈیپینڈنٹ ہیں, کس حد تک امپارشل ہیں, کس حد تک آنیسٹ ہیں, کس حد تک ہارڈ ورکنگ ہے. اب وہ 63A کی بات ہو رہی تھی, انہوں نے جو فیصلہ دیا ہے وہ ملزم کو پارلیمنٹیرین کو سزا دی ہے آفنس کمٹ کرنے سے پہلے. وہ اس کا آفنس اس وقت کمپلیٹ ہوگا جب وہ اپنی پارٹی کے خلاف ووٹ ڈالے گا, لیکن آپ اس کو سزا اس سے پہلے دے رہے ہیں اٹیمپٹ کی. تو اس قسم کے اگر آپ اور کسی وجہ کی اور کسی بنیاد پہ انٹرپریٹیشن ہو رہا ہے کانسٹیٹیوشن کا, تو آپ 10 اور کانسٹیٹیوشنل کوڈ بنا لیں. اگر مجھے ہی بننا ہے جج تو پھر تو یہی حالت رہے گی, امپروومنٹ تو نہیں آئے گی.
Dr. Sadaf, if you want to add anything on the structure bit, جو انہوں نے بات کی کہ اگر بنائیں تو اور 199 کی اوریجنل جوریسڈکشن ہم لے لیں ہائی کورٹ سے, تو how would that work in practice?
اگر جوریسڈکشن اس طرح سے لی جائے, ویسے تو آئی تھنک فرق ماڈلس ہیں. سو دیر از دا پاسبلٹی, ایک تو یہی کہ دیر آر کانسٹیٹیوشنل کورٹس جس پہ صرف ایگزیکیوٹیو ریفرل ہوتی ہے یا لیجسلیٹو ریفرل ہوتی ہے فرام دا لیجسلیچر, prior to the passage of a bill or after the passage of a bill. I think that there are other ongoing cases ka only to the extent that a constitutional interpretation is required for the application of a law or rule. یہ ہو سکتا ہے. So I think it's not, جب ہم structure کی بات کرتے ہیں, it's not a zero sum or black and white game, right? So بہت سی gradations ہیں, possibilities ہیں, and I believe other guests here may have other things to say about what the possibilities for structural reform are. So but I think میں اس بات سے بھی agree کرتی ہوں کہ to have invested a greater amount of resources in all the levels of the judiciary may also have been, a way of achieving, obviously, the dispensation of justice in a more equitable fashion for everybody engaged. So, ye design, again, these are questions, but koi hard and fast rule nahi hai, and I think that obviously the possibility of tailoring these things exists. And while we might, maybe our constitution has an answer to all of our ills, but to also be open to the possibility of redesign is also not a problem, because I think یہ اگر سوچا جائے کہ to fight extra constitutional powers that might compromise the integrity, independence, possibilities of interpretation within constitutional parameters, I think کچھ values کی بھی بات ہوتی ہے کہ against unitary interpretations, what are the ways in which we foster pluralism, and وہ ایک broader societal feature ہے. So I think if we keep in mind کہ ہم کون سی values پہ پہنچنا چاہتے ہیں, اس میں there is a role for constitutional redesign or tinkering as well, possibly. لیکن obviously the political fallout of that is much more extreme.
I think we're running out of time because they need the hall. تو یہ جیسے میں نے کہا کہ یہ گفتگو جاری رہ سکتی ہے, آپ پینلسٹ سے بھی بات کر سکتے ہیں, but we thank everybody for coming, and I especially thank the panelists, Raza Saab, Dr. Sadaf Aziz, Rashid, Rizvi Saab, Professor Antonio. We are very grateful. It was a privilege, and thank you.